to thank all of you for coming to talk about what I think is a really important and sometimes neglected topic here in Washington, D.C. and elsewhere. So we're here to celebrate Annie Byrd's book, which came out a year or so ago, but hasn't had proper socialization, and so this is a great opportunity. And we're also very lucky to have Ambassador Rapp here with us today to reflect on his experiences in the administration and now outside of government. So I wanted to just give you a quick summation of how the program is going to unfold, and then we'll dive into the presentations. So first, we're going to have Ambassador Rapp speak a bit about his reflections on the Obama administration and how they handled justice and accountability issues from his perch inside government. And then we're going to have Annie speak a little bit about the book for about 15-20 minutes. And then we'll have an opportunity for Q&A, so a real dialogue with members of the audience. So without further ado, I want to introduce our two very special guests, and then we will get started with Ambassador Rapp. So most of you are familiar with Ambassador Rapp, but for those of you who aren't, Stephen Rapp served as the U.S. Ambassador at Large for Global Criminal Justice from 2009 to 2015. In that role, he coordinated U.S. government support to international criminal tribunals, including the International Criminal Court, as well as to hybrid and national courts responsible for prosecuting people who committed genocide, war crimes, and crimes against humanity. From 2007 to 2009, Ambassador Rapp served as prosecutor of the Special Court for Sierra Leone, which, as you know, was responsible for prosecuting Liberian President Charles Taylor. And from 2001 through 2007, he served as senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda, where he led the trial team that achieved the first convictions in history against leaders of the mass media for the crime of direct and public incitement to commit genocide. Ambassador Rapp received a BA from Harvard College and a JD from Drake University Law School. So without further ado, join me in welcoming Ambassador Rapp to the stage.
Thank you very much for that really nice introduction. You know, it's just such a wonderful honor to be here for the launch. We were going to call it the launch, but I think it's the reintroduction to Annie's book. I remember a year or so ago I was talking about Annie, and they said she wrote the book on transitional justice.
Quite literally.
And this is the book, and I hope you'll all get your copy, and I'm sure many of you have probably looked at it and looked for your name in the index already, and the names of people interviewed. The first time I met Annie was indeed to be interviewed, and I think you will find here that on the 26th of July, 2010, she interviewed me particularly about my work at the Special Court for Sierra Leone, and also about what was happening in the Obama administration in terms of our engagement with the International Criminal Court. And it was an impressive introduction to her and the perceptiveness of her questions. It's a great work and a great first work. I know I'm often interviewed. I'm a person that can never say no if there's an opportunity for me to talk. And quite often I find that perhaps the person didn't have the whole picture when they wrote the book. With Annie, this tells it exactly right. She's opened the black box of U.S. foreign policy in a very complex area, and shown how it really works. The next time after I interviewed her, and before the book came out, that I heard her name was a communication from the Deputy Secretary of State of the United States, Bill Burns. And it's the only time I ever had a communication from him on a personnel matter. This person with great wisdom and knowledge and diplomatic skill, and a leading candidate to be the next Secretary of State of the United States. His message was, I just was talking to an Annie Byrd, and I think she would be a fantastic addition to your office. Unfortunately, at that time, our office was over full. In fact, we were holding down more positions than we were entitled to, but I was thrilled that my friend Rick Barton was able to bring her quickly aboard at CSO, where she continues to do great work on atrocity prevention, and particularly on the relationship between atrocity prevention and accountability and justice, which is very much the theme of this book. It's the whole theoretical framework, I think, is quite perceptive and well understood even from before she entered the government. The sort of dynamics and the cross currents that affect the development of U.S. policy, and that in the area of transitional justice, our approach is to some extent dictated by sort of three different motivations, which are symbolic, retributive, and strategic. And that analysis goes through this book and reflects indeed the experience that I had in the United States government, serving for 6 years as ambassador at large. And thrilled also to see my predecessor, Clint Williamson, here, who was my immediate predecessor and actually served for 9 months during the tenure of President Obama and Secretary Clinton before I was confirmed to the position. My own approach to this, I think, and what resonates with me is the symbolic aspect of it. And symbolic may not sound like the sort of tough part of it or the important part of it, but this is the part that I think is essential to who we are as a nation. We often talk about the battle between a values-based foreign policy and an interest-based foreign policy, and I will be one who say that I come down squarely on the values side, and particularly the value of enforcing adherence to human rights. And an essential way to do that, of course, is to hold to account individuals who commit the most serious violations of human rights, particularly our right to life and physical integrity, which is taken by the thousands, tens of thousands, hundreds of thousands in the commission of mass atrocities. And it's our values and our support for those values and the consistency with which we approach this issue that I think underlies our strength and deepens the support that we receive from peoples around the world. I won't go through my usual speech of talking about Nuremberg and quoting Jackson and how the United States was a leader in this whole process, and about how we had the interruption of the Cold War and became again a leader in creating and supporting the internationalized tribunals for the former Yugoslavia, Rwanda, and Sierra Leone, and other countries that had suffered from mass atrocities. My part of this was, of course, working in two of those tribunals and closely with two war crimes ambassadors, Pierre Prosper and Clint Williamson, and also seeking the assistance and guidance of David Sheffer, who'd held the position during the Clinton administration, and benefiting when I was in Rwanda and benefiting when I was chief prosecutor in Sierra Leone from the strong support and good relationship with the government of the United States. When I came on as ambassador at large in September of 2009, we were in a place where these tribunals were closing. They still had cases to finish, individuals in trial. I led the prosecution of Charles Taylor until through the conclusion of the prosecution case and into the beginning of the defense case, and then left it in the capable hands of my courtroom deputy, Brenda Hollis. But there were other courts that were still struggling to get their last fugitives, the ICTY, getting Mladic and Hadjic at that point, and the need to complete the work in the Rwanda tribunal, which included then more than 10 fugitives that were still on the run. So completing that task was very much a high priority of the United States for tribunals that we had supported from the beginning. But we also were facing the situation of the International Criminal Court, and the United States had been in Rome, played a key role in the drafting of the substantive provisions of the ICC statute or treaty, signed that treaty at the end of 2000, and then walked away from it in 2001 with the so-called non-signing letter by the Undersecretary for Non-Proliferation, and also the American Service Members Protection Act. But we were in a world in which there were unlikely to be future international criminal tribunals established at least by the Security Council, possibilities certainly of other mixed courts or hybrid courts or national prosecutions, which the ICC recognized should have primacy. But when it came to the international level, it was the ICC that was really the only game left. And I was very pleased that the United States was able, and through an interagency process and an end with unanimity, to re-engage then with the ICC. We had supported or not opposed the referral, even in the Bush administration, of the situation in Darfur. But beginning, and indeed by 2008, we're even becoming a very strong supporter of that action. But we hadn't actually gotten in and begun working with the ICC or participating in its assembly of states parties as we were entitled to. So that engagement, and eventually using the law and the provisions of the Dodd Amendment, which allowed the United States to provide case-by-case assistance, I think it resulted in the United States becoming essentially a non-party partner, as John Bellinger calls it, of the ICC, and particularly assisting in bringing some of its key fugitives to The Hague, Bosco Ndaganda, who surrendered to us at our embassy in Rwanda in 2013, and Dominic Ongwen, the number 2 in command under Joseph Kony, who surrendered to our contingent in the counter-LRA mission and actually was flown in U.S. military aircraft for some 1,000 kilometers from Obo, starting up in the north to Samwanja, down to Obo, and then Obo to Bangui, essentially sending the message that the United States is prepared to do what it could to assist justice everywhere in the world. And indeed, that has increasingly become our message whenever there are serious violations of human rights. You need to hold the individuals who committed these violations to account. If there's an international court, turn them over. Or develop your own fair process, even where the perpetrators represent powerful interest and have strong support. You can't just turn the page, or you risk recurrence of the crime. Indeed, there's the research of Catherine Sinkink, who I was on a panel with at Harvard this last Friday, that actually shows that countries that take this action and demonstrate that there's no impunity, even for the powerful, have lower levels of interpersonal violence afterwards. The United States has gone on with its commitments, even in cases involving leaders that may have supported the United States in terms of its strategic interests in the past, or were allied with the United States in the Cold War. People like Ephraim Rios Montt, the former chief of state of Guatemala. Our ambassador attended the trial for genocide. I went with my team to Guatemala and encouraged the trial to continue at a time when it appeared that it was going to be interrupted. We've supported the prosecution of Hissan Habre, who the United States had supported in the 1980s against Gaddafi's proxy. But during the course of his leadership in Chad, he committed mass atrocities, including as many as 40,000 detentions and instances of torture, and more than 10,000 of his people murdered in custody. We recently supported the prosecution in Spain of a former vice minister in El Salvador who was involved in the abduction and murder of Spanish Jesuit priests. And we worked closely with the prosecution in the countries themselves. I was just in Central African Republic 2 weeks ago and was so happy to be joined there by 2 of my fellow colleagues, my former colleagues from the Office of Criminal Justice, Anna Cave and David Mandel Anthony, in supporting the Special Criminal Court. And the United States has provided leadership in that, a mixed court in a country where there's really never been an adequate justice system, a country where there is ICC jurisdiction, but ICC will only prosecute 2 or 3 people, and it's necessary for us to have justice at the ground level, involving the scores of individuals that have committed mass atrocities on an increasingly sectarian basis. In South Sudan, even though we want very much to have a peace, we've insisted, as has civil society, on the establishment of a hybrid court there that can deal with the crimes, particularly that have been committed since December of 2013 in tragic situations, which has cost the lives of thousands of individuals and has more than 100,000 people living in squalid camps because they can't go home again for fear that they will suffer the fate that their sons and brothers and wives suffered. Annie is also, and these are all things that I think are so important, the message that we send in terms of our symbolic support for human rights and the importance of a value-based foreign policy. Annie also, if you've read the book, describes the role that the American tradition of retributive justice plays. And I know some people are uncomfortable, and I know when I was a defense attorney in my earlier career and you talked about retribution or rehabilitation or deterrence, et cetera, you'd say, well, retribution, this sounds like revenge, and it's not something that's consistent with justice. But indeed, as one deals with the victims of these crimes and the horrible losses and the horrible pain that's been inflicted by selfish and brutal leaders, the idea that it's respect for those victims and the suffering that requires that those who are the authors of those crimes face a serious punishment, and not an inhumane one, but a punishment that truly reflects the seriousness of the crimes that they committed and may in fact by that deter others. And it's important to understand that even while sometimes we have challenges in our country in terms of building bipartisan support, I've noticed in Congress and continue in my post-ambassadorial career the last 14 months to find that in part because of this attitude, it's possible to build support for justice in ways that people wouldn't suspect. In Congress, the support in Congress on a bipartisan basis for the victims in Darfur was one of the reasons why the Bush administration went along with the referral to the ICC. When I was prosecutor of the Special Court for Sierra Leone, I went constantly to Congress to press for more funding, even more than the State Department wanted to provide us, but it was essential to finishing the trial of Charles Taylor. And I found senators on both parties sort of competing for who would offer the amendment to provide us with more money, because they knew what Charles Taylor had done in Liberia and what he was doing in Sierra Leone. The rewards legislation, which we were successful in pushing through in 2012, was sponsored by Congressman Royce and Senator Kerry, and eventually was passed, even though it provided rewards for people that were sought by the ICC, without a single voice or vote against it. And it was a reflection of the fact that members of Congress see those victims and see the suffering and think, oh, we need to get those authors of these crimes, the people that would selfishly take and destroy the lives of others. We see even now with bipartisan legislation, the Caesar Civilian Protection Act, to come down hard on the Assad regime, and if it can be proven, the aiders and abettors in Russia and Iran for the intentional crimes against innocent civilians and humanitarian actors in Syria. And it's because of this desire to stand with the victims against the oppressors. But standing with the victims, I think, also means that we listen to victims and we recognize that vengeance alone, a process of prosecuting a few individuals for these crimes, is important, but there are other things as well. And I think our approach to transitional justice and looking at it from the victim's point of view, to the powerful interest they have in establishing the truth, in finding out where their loved ones are, and dead, and identifying them if they're dead, and determining what happened is an important part of it, even if you don't have a judicial process. One of the things that's motivated the United States in its strong support of the International Center for Missing Persons, or Commission for Missing Persons, that's now been recognized as an international organization and is cited in The Hague, where I work, and other efforts as well to establish reparations or other guarantees of non-recurrence are very much part of that sort of victim-centered approach, which arises from really considering the brutality of these crimes and what the victims need after their commission. Of course, there are the strategic considerations and important ones. We know that sometimes the strategic circumstances, essential interests may override, at least for a time, the push for accountability. I was at Nuremberg 10 days ago today for the commemoration of the 70th anniversary of the Great Judgment against the Nazi leaders. And of course, there we made common cause, as we had in our efforts to defeat the Nazi regime with the Soviet Union, with the government of Joseph Stalin. And of course, it was impossible to prosecute crimes that the Soviets committed against the innocent. But nonetheless, we, with them, conducted a process that the Justice Jackson described as the tribute of power to reason, and judged individuals fairly, and judged them on the facts and on the law. Even in that great trial of the leaders, acquitted 3 of the 22 that were charged. And though nothing is ever perfect, one of the discussions that we had last week, or 10 days ago, involved one of the more challenging things that they dealt with at Nuremberg. The Soviet prosecutors insisted on putting in the charge against the Nazis the one crime of millions for which they were not responsible, the massacre of more than 20,000 Poles in the Katyn forest that was made under the order of the Politburo led by Joseph Stalin before the beginning of the war between the Soviet Union and Nazi Germany at a time when indeed the Soviet regime was occupying eastern Poland and the Baltics. Of course, we suspected then, and it was confirmed later, that the crime had been committed by the Soviets. Interesting case. Evidence was presented on this issue and weighed by the judges. And in the end, the judges did not convict the Nazis for that crime. And interestingly, the Soviet judges did not dissent from that non-verdict. But it does show that no matter what the strategic relationships are, whatever the political pressures are, the important thing is that we cannot compromise our values, and particularly our value in achieving the truth. And of course, in the end, we should also seek justice in the long run when it becomes possible in all of these situations. Essentially because it is our values, it is our support of justice, it is the support for the weak against those who would brutally and selfishly destroy lives that I think is one of the reasons that the people in the world follow us. And we now, in this century, as are a great country, but one that's no longer the economic leader. Europe has a larger GDP than us. China recently surpassed us. As we go forward in this increasingly multipolar world, the genuineness of our commitment to justice and values is essential to our success as a nation and to the support that other countries will want to give us on issues of vital concern around the world. Just some thoughts about the overall context of Annie's book. But if you haven't bought it, buy it. And in these 3 case studies, as I said, it's accurate, but through it shines, I think, the commitment of this young woman to to justice and to the ways in which justice serves our greatest interests and our greatest interest particularly in ensuring accountability after the commission of mass atrocities, and by doing that prevent these atrocities in the first place. So with those remarks, let me yield the floor. Thank you very much for your attention today.
Well, that was a ringing endorsement of the book, so I think my plug for the book doesn't have to happen now. As many of you know, Annie Byrd serves as a senior policy advisor on atrocities prevention at the State Department and the Bureau of Conflict and Stabilization Operations. But she also has over a decade of experience working in the field of human rights, transitional justice, and conflict prevention, including at the International Center for International Justice, UNICEF, Benetech, and many other organizations in West Africa, Southeast Asia, and Latin America. She's also taught courses on foreign policy and international organizations at UC Berkeley and at the London School of Economics. And she's published her research on transitional justice, state responsibility for human rights violations, and the classification of armed conflicts. So we're very fortunate to have the author of this wonderful book here with us today to talk a little bit about how she sees the role of transitional justice in U.S. foreign policy. Dr. Annie Byrd.
Thank you. Thank you. Hello, everyone. I want to extend my warmest thanks to each of you for coming today, many friends and colleagues in the audience, and I'm so grateful for those of you that are here. If you want to come up, there's front row seats. A really special thanks to Ambassador Rapp for really providing the perfect keynote, I think, for this book. You can hear by listening to him, I think the breadth and depth of his experience in the field and how absolutely essential it is to have someone like him at the forefront of U.S. foreign policy on transitional justice. So really, really grateful for your comments. Of course, some more thanks to Shannon Green and Elliot Hecht at CSIS. They have taken on this issue at the center, and I'm so appreciative for them for providing the setting for tonight's conversation. I also want to acknowledge just a few of you in the audience. We're lucky to have 2 of the 5 war crimes ambassadors here this evening, not only Ambassador Rapp, but former U.S. War Crimes Ambassador Clint Williamson here in the second row, who was Ambassador Rapp's predecessor, and also an interviewee for this research, and very, very grateful for you being in the audience. We also have Jane Stromseth, who is a deputy to Ambassador Rapp for many years, and key to the development of U.S. foreign policy and transitional justice. Thank you for being here. Zach Kaufman is an academic in this field and has also written a book on U.S. involvement in transitional justice, so plug for his book. And then finally, I want to acknowledge my husband, Yuki Shinomiya, who not only helped me get through the book, but also is selling books after. So, that's very grateful to him. So thank you all so much for being here. So a small disclaimer before I begin. Although I now work at the State Department, today I'm speaking about, in my private capacity, about research that I conducted before work at the State Department. So won't be representing official State Department views. So to start, I thought I'd share a little bit about my motivation for writing the book. The idea began to be formed over a decade ago now, which seems crazy, while working at the International Center for Transitional Justice in New York, and really seeing up close the rapid growth of this field called transitional justice. The field was really spurred on by responses to mass violence in Rwanda, the former Yugoslavia, apartheid in South Africa. And so I was struck by the field's aim to respond to societal calls for justice after periods in which serious human rights violations and abuses had been committed. The field's advocates argued that justice in these so-called transitional contexts needed to be holistic and encompass a range of measures, not only criminal accountability, but truth-seeking, reparation, institutional reform, reconciliation, big ambition. It was argued that a comprehensive response to past abuse would help deter a recurrence of violence and support a lasting peace. At the same time, I was also struck by the explosion of global actors becoming active in this space, from donor governments like the US to multilateral organizations, to think tanks, to NGOs, to universities. It was becoming more and more clear that if you cared about peace, security, or development, you couldn't overlook the justice issue. I could tell that these global actors seemed to have a significant influence over the way in which transitional justice was being carried out in societies that experienced abuse. But how and why these players were involved in transitional justice was less clear to me. The US looked to be one such actor that held a particularly important role, providing extensive political, technical, and financial assistance to measures established around the globe. Despite this important role, however, no study that I could find had offered a systematic explanation of the US approach to the field, a gap which my book, US Foreign Policy on Transitional Justice, tries to fill. So I decided to examine the development of US foreign policy over time and through 3 illustrative case studies. These case studies were all representative of the diversity that we can see in the field. In addition to extensive document review, I conducted nearly 200 interviews on 5 continents for the research. I met with government officials, staff working in transitional justice measures, representatives from international organizations, NGOs, as well as academia and the media. It was the analysis from this rich material that led me to the central argument of the book, that US foreign policy on transitional justice can be characterized by a distinctive approach that is symbolic, retributive, and strategic. So by symbolic, I'm referring to the symbolic role that justice plays in American society. In the US, trials in particular are seen as an enactment of justice that makes sense of an event through a simplified story that assigns blame to a high-level perpetrator, like Pol Pot in Cambodia or Charles Taylor in Liberia. And by getting the bad guy, trials reinforce a narrative about good versus evil that connects to deeply rooted US values. Second, I argue that the preferred US model of transitional justice is retributive, meaning that the US focus on punishing a perpetrator primarily through criminal prosecutions over victim-centric mechanisms like truth commissions and reparation programs. The American tradition of punishment through law, coupled with a US foreign policy bureaucracy that has dedicated significant resources to supporting criminal prosecutions, has meant that the US tends to provide greater support to trials than other models of transitional justice. Finally, I argue that you cannot discuss the US role without examining the way that it uses measures instrumentally to advance its strategic interests or blocks transitional justice when it fails to advance these interests. In contrast to the other 2 features I just discussed, the strategic nature of the US approach explains the variability in when the US gets involved and, once it gets involved, any fluctuations in US support. This characteristic of the US approach, I find, also helps explain the ambivalence and inconsistency that some have asserted is present in the US response to atrocities. So let me illustrate my argument about the US approach through some examples from the case studies. So my first case study examined US involvement in Cambodia and the Khmer Rouge Tribunal. So in Cambodia, nearly 20 years after the genocide and after years of domestic pressure, Congress made it US policy to investigate and help establish a tribunal for the crimes committed by the Khmer Rouge. This 1994 legislation helped set the parameters for Cambodian transitional justice early on by focusing on the documentation of crimes that could be used in legal proceedings. Through congressional funding of an NGO called the Documentation Center of Cambodia, the US supported gathering much of the evidence that made the eventual trials possible. For years, members of Congress and the State Department then pressed the UN and the Cambodian government to establish a tribunal, but also worked to ensure that the tribunal's jurisdiction was limited to a small number of top leaders responsible for certain crimes during a very specific time frame. Then, after pushing for the establishment of the tribunal, Congress then refused to fund it because of distrust of Cambodian Prime Minister Hun Sen. Eventually, this funding block was lifted based on the efforts of a few key individuals, and the US again provided funding and technical assistance to the court. My second case study looked at Liberia, specifically 2 measures. One, the prosecution of Charles Taylor at the Special Court for Sierra Leone, and also the Truth and Reconciliation Commission that was established in Liberia. So in Liberia, the US policy of non-intervention in the country's 2 civil wars changed in the early 2000s when Congress decided that Liberian President Charles Taylor had to go. Discussions for a war crimes tribunal were already underway in neighboring Sierra Leone, which offered one way to remove Taylor from power since he had committed war crimes and crimes against humanity there. This idea was dismissed when the option to grant him asylum in Nigeria appeared to be a more expedient way to achieve this goal. Congress, aided by an active civil society campaign, specifically focused on Taylor's prosecution and kept the idea for prosecutions alive, pushing the Bush administration and the State Department to transfer Taylor to the special court for Sierra Leone to be tried for war crimes. Meanwhile, to meet the calls for transitional justice that remained in Liberia, the US viewed a Truth and Reconciliation Commission as an acceptable alternative to trials, since the US was unwilling to support another tribunal in Liberia, considering its extensive support of the Sierra Leone court. The US did provide some technical assistance to the Truth Commission, but decreased support when the commission recommended sanctioning President Ellen Johnson Sirleaf, a leader the US heavily supported. My third case examines Colombia, the Colombian Justice and Peace process, which was established in 2005, obviously not the current process that we're seeing. In Colombia, Congress advocated for the strengthening of provisions of accountability in the Colombian Justice and Peace law, while the Department of Justice at the same time pushed to maintain its ability to extradite top drug traffickers that would participate in the Justice and Peace process. Ultimately, both congressional and Justice Department interests were met. The investigation component of the law was strengthened, and it did not prohibit extradition. A few years after the law's passage, Colombian President Uribe decided to extradite several top paramilitary leaders to the US, which observers believed undermined the Justice and Peace process. So what do the book's findings mean for all of us? I would offer three propositions. The first is that transitional justice is now part of the US foreign policy toolbox. Issues related to justice and accountability cannot be overlooked by US foreign policymakers, given the centrality that these issues play in achieving lasting peace and security. But being part of the diplomatic toolbox means that the issue is subject to the classic tension between interests and values that we see in other areas of US foreign policy. It also means that transitional justice is subject to the diverse and changing interests within the complex US foreign policy architecture. But as a relatively new area of foreign policy, it's still possible for key individuals to have oversized influence. The second conclusion I think we can draw from the book is that the US preference for criminal prosecutions has contributed to the spread and prominence of the trend in world politics towards holding individual state officials criminally accountable for human rights violations, what some have called the justice cascade. The idea here being that this growing global norm has been influenced by US conceptions and models of justice to individualize responsibility and deliver justice within the confines of a trial. This US preference also means that other transitional justice measures receive less attention and support. Finally, the US approach risks being disconnected from the transitional justice goals of the societies that have experienced abuse. Considering that these goals are often broader than holding high-profile perpetrators accountable, a focus on punishing these individuals may in some cases be too narrow of an approach, or even counterproductive for societies that prioritize truth-seeking, reparations, or other measures that promote reconciliation. US prescriptions for transitional justice that fail to consider the populations that have considered abuse may fail to achieve the underlying purpose of the field, to deter the recurrence of violence and support a lasting peace. So with that, I'll close. Really looking forward to discussion. And again, thank you so much for being here tonight.
Thank you. Great. Well, I'm going to take the moderator's prerogative to ask each of you a question, and then we'll open it up to the audience. First, both of you talked about values-based foreign policy and the difficulty of adopting such an approach all the time for a number of reasons, including our strategic interests. Obviously, we're at a critical point, given that we have an election coming up in the United States. How do you make the case to the next president, which varies wildly by who gets elected, for why having an emphasis and a more consistent approach to transitional justice is important? Maybe that one can go to Ambassador Rapp. And Annie, for you, it struck me in the book and in your description, you do talk about a U.S. approach, which is very unique. Given that we as a society are much more focused on retributive justice, how does that affect our ability to engage and collaborate with other actors, particularly in Europe, that take a more holistic approach?
Well, we look at a world right now where we have, I think, 65.3 million people refugee status, both internal and externally, which is a greater number than ever before in human history. A great many of them are fleeing situations of conflict, but not just conflict. Conflict in which civilians are the intentional target of that conflict. It's not like the war on the Western Front 100 years ago when relatively few civilians were killed and combatants bled horribly, but it's now a situation where it is so much more dangerous to be an innocent woman or child, a doctor, a humanitarian actor, than it is to be a rebel or a soldier, to be frank, if you look at the numbers of casualties. And this creates profound problems, and this is the relationship between this issue and the realpolitik of it. When hundreds of thousands of people are trying to get into Europe, when there are dislocations in other countries as a result of the failure to respond in terms of the atrocities that are being committed in one place, and when people aren't being protected, and when instead they decide to throw in with the jihadists because they're the only people that will protect them, it has profound implications. I saw it in an earlier case in Rwanda and the Congo, where I spent more of my just sort of justice career than anywhere else. Went there to the DRC 15 times and Rwanda 14 times as ambassador at large. But the atrocities in Rwanda killed 800,000, and people said, well, Rwanda, no oil, no other resources, it's only goods for export or coffee and tea, no big player in any kind of international set of alliances. What does this matter to us? But as a result of the atrocities, 2 million people flee the country, profoundly dislocating the resource-rich DRC, and the repercussions of that continue, as the repercussions of what's happening in Syria or Yemen or elsewhere happen today. And a key part of this, I think, is that we've got to figure out ways to enforce these norms, to create the very clear perception that if you commit these crimes, you're going to be held to account. And it's challenging, obviously, given our global system right now, and with Russia blocking us and now actually aiding and abetting the crimes of Assad. But we've clearly got to show that there are consequences to this kind of conduct. And certainly we're doing that in support of human rights inquiries and documentation efforts and everything else. But if we can be more effective in that goal of preventing people from carrying out these campaigns where basically they decide that in order to retain power, they're going to demonize a particular group and hammer that group in order to show their continued control and really demonstrate that there are consequences to that, it creates a more stable world. And these repercussions, they're not just immediate. If people are bloodied, consider the Armenian genocide. It's not something that ends even with the life of the immediate survivors. And other situations where conflicts in the Balkans and the desire for vengeance create ongoing tensions. And a key way that we get away from this is by holding individuals to account, presenting the very accurate story that it is not a group of villagers, a group of neighbors that go out and decide one day that they hate their neighbors, people that they've worked with and lived with all of their lives. They're being goaded into it. They're being organized to do these kind of things. They're being the scab is being picked, and if we focus on the real perpetrators, who are the ones that are seeking to benefit from these, and that should be the focus of our prosecution, then I think it helps us get past and really build the foundation for for reconciliation and for more permanent peace between people. So it's challenging, obviously. Some places we've been able to succeed, other places we haven't. But it can work, and just because of the realpolitik of it, I think there's a strong reason. Of course, you already heard my pitch for values-based foreign policy, et cetera, and why I think it's important to be true to these values. But in this case, both interests and values, I think, yield the same answer.
Yeah, thank you. I mean, just to comment on the first question briefly, I think it's just become increasingly clear in all of the cases that we've been looking at that you can't address security issues and lasting peace issues unless you talk about justice. It will keep coming back to bite you unless you address it. And so we all, those of us that are active in the field, need to be finding examples and arguments to make that case effectively to diverse audiences. I found that it's clearly on the agenda and will be on the agenda whether it's going to come up with it if you don't address it. On the engagement with Europe, I think what was interesting in the book is really looking at, there's a very small handful of donor governments that are active in this field. It's literally very a handful. UK, Netherlands, Japan, Canada, the Swiss are obviously very engaged in transitional justice. The EU has gotten more and more involved. I was hoping, I think a good follow-on study would be to do some comparative work with some of these other countries that have taken different approaches to the field, considering that it is such a small group, wouldn't be that too hard to do. I think the Swiss are the most kind of forward-leaning in how they talk about transitional justice. They have really, they talk about the need to have a more holistic, they talk about truth-seeking and reparations, I think much more than the US used to. That being said, the State Department did recently come out with transitional justice papers that talk about the suite of and the range of transitional justice tools, and so I think there is growing acknowledgement within the State Department at least about the kind of a more holistic response to transitional justice. But I think there is, in general, a divergence between how the U.S. has approached it and these different actors. Yep.
Great, so we're going to open up the floor to your questions and comments. I just want to note that we are live streaming this event, so it is on the record. So not that anybody would ask a question they don't want to be on the record, but just letting you guys know that that is the case. So go ahead.
Yes, my name is Annie Byrd. I'm with the Pakistani Spectator. And my question is about Secretary Kerry's. He gave a clue last week that Russia could be charged for war crime in Syria. Regarding this, doesn't it make a very weak tool when we apply this very selectively? And what I'm saying that about India, Pakistan, India has claimed that Pakistan has killed thousands of Balochi in Pakistani Balochistan. And similarly, Pakistan has claimed that India has killed hundreds of thousands of Kashmiri in Indian Kashmir. So if we apply the same tool that in South Asia that John Kerry wants to apply in Syria, using as a pressure tool, we could have resolved or close to resolve this Kashmir issue. But since we don't do it, so US is normally charged in third world countries, especially by China, using it as a hypocritically that, we use it as a human rights issue just because we want to forward or advance our foreign policy the interest rather than being sincere or genuine. In other words, they charge us for intellectual hypocrisy. What are your thoughts on this? Thanks.
Are there other questions? Because we can actually take a couple at a time. The gentleman in the back.
Thank you very much. My name is Tyler Thompson with USAID. Hi, Annie. Thank you, Ambassador Rapp. My question is there, in your research, did you find a trend or a tendency towards domestic versus international or hybrid approaches, and what might be the strategic reasons for whatever you found there? Thanks.
right, so let's take those two.
Well, let me jump in on the first one and understand there are horrible things happening in a great many places. And if you read the human rights report that's issued each year by the Democracy, Human Rights, and Labor Bureau, written by them and issued by the Secretary, you'll see, I think, mention of these problems everywhere. What's happening in Syria now, however, is the most acute and dramatic, when we have probably 450,000 people killed and millions of people as refugees, and where we have something that we hadn't seen, we didn't even see in World War II, norms regarding the protection of humanitarian actors totally and completely flouted. I mean, hospital, ambulances now cover themselves with mud so they're not white, and cover up their Red Crescent or Red Cross in order to avoid being targeted with. In a period of just a few months, 700 doctors and other medical workers were killed by Soviet and Russian bombardment. That was a number that was given by PHR just 3 months ago, and it's become more serious since. Humanitarian convoys hit, and 19 of 31 vehicles are destroyed, even during a ceasefire. These are, if this becomes the rule in conflicts in the future, then we can look for even bloodier and more vengeful violence, and we can look for more people. And indeed, the design of all of this is to make life impossible for the people underneath these bombs. So they've got no choice but to get out and stay out. Worse than even the kind of ethnic cleansing that was conducted in the Balkans, which had the same sorts of intent. So it's important to speak to the strongest cases. Obviously, talking about the Russians is a challenging one, because obviously the Russians have voted to block ICC referral by the Security Council of the Syrian situation. Clearly, they would block it for themselves, even more so than they would block it for their friend Assad. But I think the message has to be that when these crimes are committed, there needs to be accountability. I know people say, well, don't American bombs sometimes kill civilians and doctors? Indeed, the same PHR report said, I think, that coalition's airstrike had killed 1 doctor compared to 700 on the other side, and clearly a mistake. We investigate when shells go astray and when civilians are killed. The Russians refuse to investigate. They deny, even the obvious facts of where their planes are, or where the shells landed. We acknowledge that, and when civilians are killed, we in the end, issue reports regarding how it happened, and attempt to, as in the case in Afghanistan and Kunduz, hold people at least to account in terms of their military rank or positions, and potentially seek their discharge. I mean, there are things that are done that can be effective, and the fact that the Russians aren't doing anything from a criminal law standpoint means they're taking no action to prevent or punish this conduct. And as such, anybody in the chain of command, including the very person at the top under international criminal law, is responsible for the crimes of which they had knowledge or reason to know. And that's why this case is a strong one, and it's right that the Secretary bring it out, and then we continue to need to seek ways to achieve justice in the long run in these cases. Regarding the question of hybrids or national, I do think that even while we have the International Criminal Court as a permanent international court with jurisdiction in 124 countries, and additionally, if it's provided by the Security Council, we recognize that court can't handle more than a few cases at a time. And in its dozen years of active operation, it's only completed 4 trials. And it's never going to have more than a dozen people probably in custody or in trial at any specific time. And so clearly, as consistent with the whole idea of the ICC as a court of last resort, being complementary to what's happening at the national level, I think the emphasis has to be at the national level, where efforts in this area of atrocity crime also help build the rule of law and corruption and organized crime and other forms of illegal activity. So I do see more emphasis there. On the other hand, we often have problems in conflict zones because of the fact that the judicial system was broken before the conflict and is destroyed after the conflict. And relying on a system under such circumstances to provide the justice is a difficult one. And so that, I think, will require us in many places to participate actively in rebuilding that justice system. And because of the challenges of capacity and independence and potential victors' justice and unwillingness of victims to deal with sometimes with their own authorities, it's important to do the kind of thing that we did in Bosnia and that we're now looking to do in Central African Republic and in South Sudan, and have a mixed institution with at least international participation for a period of time. We did the same thing in Bosnia, even though the ICTY prosecuted 161 individuals in the Bosnian state court. There have been hundreds of individuals prosecuted and in a much more efficient way than frankly at The Hague. And so that kind of approach, I think, will increasingly be a better approach, though it is challenged by the need to get resources for it. And as when I was special court prosecutor, I spent a lot of time raising money, and those of my colleagues in the State Department know that raising money for these institutions is an extremely challenging thing, but it's money well spent.
Yeah, no, I couldn't agree more. Just to take time.
Yep. Let Annie respond to both questions.
Yeah, no, just I couldn't agree more with the ambassador. Just to take Tyler's question first, I think there's been a clear evolution in the field from the focus on international tribunals in the 90s to more of the hybrid mechanism of this mixed domestic and international type of court that Ambassador Rapp described, to a real acknowledgement that domestic processes need to be supported more and more if this field is going to have the lasting impact, not only for the benefit of the field overall, but really for those societies that we are talking about. The most impact typically comes from when there are mechanisms that are established in country. So this has been an evolution of the field. You ask about the strategic nature of that. I think it's more about a natural evolution of the field more than that there's a strategic reason for this. I think it's again part of the move from the 90s to the present, more than kind of a strategic angle. On the issue of, I don't know the case specifically that you're speaking about, but I am very familiar with this concern about hypocrisy that you raise, that I think is absolutely crucial to bring up, and always comes up when discussing U.S. foreign policy on justice issues, given the fact that the U.S. has been involved and is responsible in some cases for the type of violence that it is trying to respond to in these other cases. So that is inherent in almost all of U.S. foreign policy, this field not excluded, and is an issue that we all have to be grappling with. What I saw through the research in this book is that the pressure that was continually placed on members of Congress, from civil society, from NGOs, from within the system, within the State Department, through offices like Ambassador Rapp's really made a difference in guiding the policy in a direction that was responding to the violations in the most appropriate way. But yes, it is undoubtedly part and parcel of U.S. foreign policy when working in such a complicated system.
At peril of not responding exactly correctly or directly to what you were saying, because I'm unfamiliar as well with the specific situations. I mean, we have engaged intensively in Sri Lanka, where it was alleged that the government's operations in the final stages of the war killed more than 40,000 civilians, and in Bangladesh regarding accountability for the crimes of 1971 that Sheikh Mujib said cost 3 million lives. May not be that large a number, but certainly hundreds of thousands of people were killed. And engaging with governments, sometimes in a quite critical way, and in both cases with friendly governments to the United States, pressing for fair justice processes based upon the facts and the evidence. And certainly when we get into, we're not talking about every human rights violation being an atrocity crime, but where you do end up in a pattern of mass atrocities with thousands killed, definitely we want to work with the government, with civil society, with victims to achieve justice in the place where these crimes occurred, and then we'll look to more international mechanisms only when it's not possible to do that with fairness and justice.
Back there. They're coming.
Thank you. My name is Mindy Cutler from Asia Policy Point. I work on World War II war crimes. Has your research shown, what have you found in your research, if at all? What happens when the United States veers on the side of strategic interests as opposed to principle, values? When it supports an agreement or ignores an atrocity, particularly supports an agreement, such as recently there was the Comfort Women Agreement, which didn't even have a written document, which violated every single principle that we've ever laid down for justice in a war crime. Has your research shown what has been the result when we don't stick to a principle? Have you done any metrics on that?
Okay, probably one more question. Probably all we have time for, and then we're going to have a nice reception out in the hallway.
Yes. Hello, Will Faragero, consultant. Annie, I'm late to the book, so perhaps you addressed this in there, but I'd like your comments on the role of media in the transitional justice processes, not only in terms of public education about the process of within these countries, about the processes of different courts and TRCs and that sort of thing, but also as an investigative complement to justice mechanisms. And then a third wrinkle, perhaps, it seems like funding from AID and state goes to rule of law, to justice. And I'm wondering if you could speak to a little bit about how one creatively funds media programs when we have a tradition of hands-off of media in our system. Thank you.
Take those. Okay. Yeah. On the first question, I think I don't have a perfect answer for you on quantitative metrics on what happens when we go on a value-based approach versus a strategic approach. I think that as you saw in the brief description of the case studies, almost every case that at least I looked at, there's an element of both going on. In Liberia, again, we saw that there was a huge support for the prosecution of Charles Taylor within the department and within Congress, purely for prosecution of Charles Taylor for the crimes. But then you also see a very clear interest in wanting to see Taylor get out of power in whichever way possible, and supporting regime change and transitional justice as a way to help do that. So again, in that case, and in the Cambodia case and in the Colombia case, I see this delicate balance between values and interests happening in every case we look at, and I would be surprised to find a case that was clearly only driven by one and not the other. On the role of the media, so I didn't actually. There wasn't a significant amount of funding that I found again in this research on supporting media organizations, specifically that were working on transitional justice or reporting on transitional justice. But I think it's an interesting question to raise on the types of media organizations that are tracking and following these various cases. Local media organizations, of course, that had different angles on the transitional justice story. So I actually didn't find a ton of U.S. funding for media organizations in these cases. It was more about the importance of the role of the media in tracking and reporting on and making sure that people in the society and in the countries where transitional justice were being established were able to know about what was going on. So that was really more of the focus of the media in the research that I could find. But it's an interesting question. I don't know if you...
Yeah, well, let me just deal with the two issues. And we know that one of the most challenging things for any country or people to do is to admit that they made a mistake, admit that they committed crimes against others. In the German case, even though it's imperfect, is a bit of the gold standard. We prosecuted at Nuremberg. At that time, the polls said 98% of Germans thought it was victor's justice. But by the 1960s, they were prosecuting their own leaders from the death camps in the Auschwitz case in Frankfurt and the Majdanek case and others. And now they're prosecuting the 93-year-old accountant. And this, as a result of that, of following up with justice, now 98% of Germans think Nuremberg got it right. And Germany is a leader in Europe after the horrible crimes that the Nazi regime visited on occupied people. We haven't had that same sort of dynamic, to be frank, in East Asia, and we press for it. We only know in our own history how difficult it is, and how no one wants the president ever to apologize for anything. Maybe regret something, if it's something in our past that we don't like. But it's something that's got to be part of our foreign policy, and with our allies, we have to push people in that direction. On the other hand, when they don't give us 100%, I don't want to necessarily grade these things on a curve, but we get what we can, and we continue to work on it, because it is really important for the crimes to be acknowledged. It's so important for the victims and their survivors, and it's so important for the country's understanding of where it went wrong, so that it won't go wrong in the same way in the future. In regard to the media, maybe the U.S. doesn't do a lot in this area. I've been involved over the course of my career in a lot of trainings that have been actually paid for by the EU and German government, et cetera, of journalists in Africa, for instance, explaining exactly what the terms of international justice mean, because even in America, most people have no idea when cases go to The Hague and when they don't, and how this whole thing works, et cetera. And particularly if you're in Kenya and following the case in The Hague, getting that right is very important. And so I do think it's important to work with journalists, not to tell them what to say, but to make sure that they have the tools to be able to follow the story. This is related to the overall question of, justice should be done, but also seen to be done. And I was proud to join the Sierra Leone Special Court, admittedly as its third prosecutor, and see that it had been developed there, the first-rate outreach program developed by our own Sierra Leonean, now the registrar of the court, Binta Mansoure, where we employed people throughout the country to provide information about the court, where hundreds of public meetings were held on every hill and in every district, and in a country where no newspaper prints more than 500 issues, where electricity only reaches 2% of houses, so that it's impossible to use television. There's some reliance on FM community radio and shortwave, but we had polling by the German Center of Torture of 10,000 people across the country a few years ago, and 90% of the people knew what the special court was doing, and about 80% of them said it was a force for stability and peace. And that wasn't because they just wanted to say nice things about us. I mean, I went to all of those meetings, and they asked us tough questions over and over again, and quoted the statute back at us about why we prosecuted this person and not that one. But it's extremely important, if it's going to have an effect, to have this kind of outreach program. And I think in the Sierra Leone court, we had a Truth and Reconciliation Commission. Annie talked about the one over in Liberia, but we had one also in Sierra Leone that didn't get a lot of perpetrators in it, but did provide a broad record of what had happened, and allowed more than 10,000 victims to tell their story, either in person or in writing. And then at the special court, we only prosecuted 13 people, including Charles Taylor, and a couple of them died before we arrested them. And so it was a relatively small number of cases. They all had to be tried, no guilty plea. But the act of actually projecting the trials and providing the whole narrative, I think, meant that it had so much more impact than if we had tried hundreds of cases in secret. It really, I think, did tell a story and help people understand what had occurred in their villages and in their country. And since then, even though the country is very poor, one of the 10 poorest in the world, and even though it's recently had the struggle with Ebola, which it's now recovered from, at least physically, there has been no lethal political violence since 2003, and we've gone through 3 elections, including one in which power changed peacefully from one party to the other.
I think this last point is really important, and that is that there are some really innovative uses of multimedia in order to get beyond just demystifying the process or raising awareness about it, but rather bringing diverse voices, particularly of victims, into the process. And some of the documentary filmmaking work that's been done in Guatemala and elsewhere, I think, speaks to that. So I want to thank our special guests, Ambassador Rapp and Dr. Annie Byrd, for their very thoughtful comments. I want to thank all of you for your active participation. And I also want to welcome you to join us outside for some refreshments and also to buy Annie's book at a discounted rate. So once again, just join me in thanking our special guests.